Public Defender Ben Dunn on behalf of Mr. Weatherspoon, who is joining me at the podium now. And sir, would you state your name for the record, please?
Terrence Weatherspoon.
Your Honor, we've worked out a deal involving a waiver and a plea at circuit court in this matter.
Correct, Your Honor. My understanding is that Mr. Weatherspoon will waive his right to a preliminary examination. The people will not file a vigil in this matter. And in circuit court, there'd be an offer for a plea to an added count of possession of less than 25 grams of controlled substance.
We've got a problem. Mr. Allen. You have his bond violation?
I do. So, well, can I address it on the record, Your Honor?
Yeah, go ahead.
I talked to my client about it. His position is that he was incarcerated. And, I think he admitted the first violation to Your Honor. He denies this one, and he's paid, I believe it was $150 for the sample to be retested at a lab. So,
a routine hearing turns into a gamble with real consequences. The judge has the paperwork. The defendant has a promise. One test stands between freedom and the cell.
Given that the retesting is in progress, I'd ask the court to defer any action to Judge Conlon, and perhaps we'd have those test results back in 2 weeks, or if they came back later than that, I'm sure the government would be addressing it regardless.
Does he have a medical marijuana card?
No, I don't. That was why I had to. Last time I asked you, I told you about the appointment, and that was the whole thing. So we trying to get a medical marijuana card right now. I got a doctor appointment scheduled on February 11th for all of this. In the cocaine drop, I don't see how it was positive, and I'm supposed to test today too, actually. So I'm trying to figure out how. I don't understand how was it dirty. That's why I paid for it to get tested again. They told me it'd take up to 2 weeks for it to come back from California. And in regards to,
well, maybe if that's the case, except that, and here's the problem, counsel. I might wait, except that his last 3 tests have been positive for cocaine, spanning from November 17th to December 26th. And then he had the THC positive in November, but then THC leaves his system, and then he's back with THC in his system again.
I speak, Your Honor.
All right. If your attorney wants you to,
Don't talk about anything before November, but I think we're fine talking to the court about his substance abuse issues. He's pretty open with it. He admits he has an issue. I'd just say to the court, I think THC opinions have evolved, and I haven't known Mr. Weatherspoon very long, but he's pretty obviously in pain to me. Frankly, I think THC is better for a person than taking opiate pain relievers. He can barely walk. I think he needs.
That's good, doctor. I don't know.
He had a doctor appointment.
Made that issue. That's not it. And it may very well be, but that's why he needs to just get a card, and then there isn't an issue.
I scheduled to make an appointment for the card. In the cocaine dirty, that's why the first time I told you, I said, Judge Simpson, I did that. This time I'm 100% sure I didn't do any drugs. So that's why I had it sent out for the test, because I know I can't be dirty for it. Would you allow me to take a test today to? I know I'm not dirty. I ain't using no drugs, man.
My name's not man.
Yes, sir. I'm sorry, sir, but I'm sorry, sir.
Just don't judge is good.
And if it comes back dirty, I just leave you in there forever.
Ever is a long time.
I know, but we're gonna make a deal. Let's make a deal.
Let's make a deal.
Is that it?
Yeah.
If you come back clean, then I get to decide what to do. Test. Let him know he's coming over to test.
Where's he going? To community
Community
corrections?
Any corrections?
All right. Obviously.
People versus Terrence Weatherspoon.
And we told the defendant we have people.
Assistant Public Defender Ben Dunaway on behalf of Mr. Witherspoon, who is approaching the podium now. And would you state your name for the record again, sir?
Terrence Weatherspoon.
Today's your lucky day. You're negative.
I told you, sir.
Huh?
I told you. I ain't you.
No, you didn't tell me.
You gave me a pass. Listen, though, you gave me a pass, sir. You,
Huh?
you reinstated my bond. I was in jail. I cannot be. I'm not gonna test dirty. I can't.
Well, we can indicate he's got a future in acting, so he is employable, Your Honor.
Okay, so he's waving up. Is that right?
He is, Your Honor.
All right. So, sir, waiving your right to a preliminary examination.
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
And you understand that you'll not have that here. You'll proceed to circuit court for further resolution.
Yes.
People also waive the right.
We do, Your Honor.
Preliminary examination hasn't been waived. Defendant's bound over on the single count.
And he did waive for the offer placed on the record 2 hours ago, or whatever it was.
Yes.
Thank you, Your Honor.
Offer of use or felony possession of controlled substance less than.
Yes.
And we will stand mute. We have the formal reading.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial will be set for
February 23rd at 1:30 before judge.
February 23rd, 2026, 1:30 before Judge Hamoud. Bond will continue. Okay, Mr. Weatherspoon, you may not think so, but I am so glad that it came out that way.
Me too.
I really, yeah, you're probably more so than I am, but I really am, because I'm just, all right, good luck to you, young man.
Thank you, Your Honor.
All right, so, yeah,
On behalf of Mr. Howard, who is standing to my right.
Time and place scheduled for prelim, and unfortunately, people are unable to proceed in anticipation of a motion to dismiss the felony counts and seek a remand on, I believe it's count 4, Your Honor.
yes, it would be count for.
And we would make that motion. We don't have a legal argument against the remand, but we would like to address bond, given that my client is now only charged with a misdemeanor.
I'll continue the defendant's not guilty plea to count 4. Counts 1, 2, and 3 are dismissed. A pretrial date in this matter will be set
January 15th at 10:30 before judge.
January 15th, 2026. What time is it?
10:30.
10:30, of course, before Judge Fresh Hour.
Thank you, Your Honor.
Is that A3 or A4?
Pardon?
10:30.
10:30.
Oh, I mean the court.
That's actually A4.
Okay. And maybe we address bond, Your Honor?
Go ahead.
So. Your Honor, my client works Monday through Thursday at Cushing Malloy Books. He works 410, so that's 40 hours a week. Then he additionally works at Hollywood Sales doing car audio Friday, Saturday, and some Sundays. So he is fully employed. He lives with his mother in Ypsilanti. He is her caretaker. She has cancer. That's on Clark Road over in Ypsi. And he does have a pretty limited criminal history, I would say. So we'd ask the court to release him to his mother's house, and the court can impose conditions as the court feels necessary, of course.
What happened? Well, there's a problem. Because the defendant initially had a personal recognizance bond, but then he violated. Yes, twice. But he definitely violated where the court felt it necessary to issue a no bond warrant on him. So what makes me think, even with charges where they are, that the defendant is going to be able to comply with bond conditions?
Well, I would say, if the court thought he strangled the person, he's a lot more of a danger to the community than if he had committed misdemeanor domestic violence. Just because of the nature of the charge, I think if you're a person that would do that, you could be considered more dangerous than a person that commits misdemeanors. He's no longer charged with a felony. The witness apparently was not interested in pursuing the case. So I don't know what happened. I think as far as him violating bond, he's certainly learned his lesson. I don't think he's a frequent flyer here that has violated bond in the past or anything like that. So if the court would give him another chance, we think he would comply this time.
I don't really need anything from the people, but I'm just going to tell you, the defendant hasn't been able to comply with bond. It now becomes Judge Freshour's issue to deal with, and I'm going to certainly leave it to her to decide the conditions of releasing the defendant. So your motion for bond reduction tonight, bond will continue.
Thank you, Your Honor.
Calls case, People versus Terrence.
Court doesn't care how confident you sound. It cares what the test says when the door closes. Today the truth walked free.